Resources for Immigrants is a private organization that provides information on relearning, rebuilding, and resettling for immigrants in Canada. The organization partners with several other organizations and businesses to offer quality services to immigrants in Calgary, Alberta. Since it was founded in June 2020, Resources for Immigrants has served over 300 immigrants, offering valuable and timely information on career development, education, immigration, and settlement, thereby changing one life at a time. You can read more about us at www.resourcesforimmigrants.ca. We are on Facebook, Twitter, and LinkedIn. Also, we have a lot of information for you on YouTube channel. Remember to subscribe. The quickest way to contact us is through our email address, hello@resourcesforimmigrants.ca. So thank you so much, Jatin, for agreeing to come here and talk to us about humanitarian immigration. We are so grateful for sharing law and the work they're doing to the community. So I would like us to talk about humanitarian immigration today. And the first thing I would like to mention is how we feel about the Afghan situation and the Afghanistan situation. And the first thing I would like us to discuss is how can the community support the refugees coming in from Afghanistan?
Well, I want to start off by saying thank you again for the invitation. This is a very important topic, I think, for newly landed immigrants and also for families that are in situations like you mentioned in Afghanistan or even elsewhere in the world who are thinking, is H&C, is humanitarian compassionate application, is that the right way for my family that's in Canada right now? Or is that even an option for families that are overseas right now? The Afghanistan situation, the way the programs work at this moment, and that might change even by the time this video is out, but the way that the programs work today, it's a lot of focus on those who have helped the Canadian government and the Army and the armed forces while we have been basically occupying in Afghanistan. I'm kind of working in that country and helping it rebuild because we all know the government left, and it's not just the Canadian government. I mean, all the governments of the world that were in there, everyone left, and it created a bit of chaos. Was it foreseeable or not? That's up for debate. That's what the leaders are talking about as we're in election time right now. But the reality is that the immigration system right now is trying, I think, its best to be able to keeping security in mind, I think, as well for our society, help those that have been helping Canada. And then I think after we'll start looking at how do we help those families of Canadian citizens and permanent residents that already exist here in Canada. It's a really tough situation because at the end of the day, it's so unpredictable. And there are ongoing negotiations. You're hearing news about it every day in terms of just developments of how the current government in Afghanistan is trying to negotiate and deal with the problem and how they're conducting themselves. I mean, it's a tough time, right? And I think the biggest issue was that it kind of felt like it just happened. And it felt almost unpredictable. In terms of families, look, we will definitely see a wave of Afghani refugees coming in, I think, over the next few months, possibly even a year. What can we do as a community is I think, help them with open arms, right? There's a ton of settlement organizations. Resources for Immigrants is one of them. I mean, these organizations are going to play a key role in terms of giving good information. Naturally, when newly landed immigrants come to Canada, they like to from any community, but they like to gravitate towards their communities. And so, the Afghani community will probably need some support from the greater community as this influx of refugees comes into Canada, because it's like when the Syrians came in, a number of years ago. And the community, I think, in Canada as a community definitely came together to help these individuals. And it's been years and almost a generation shift even for the Syrian community. And I think that help initially was great because of that. I have a lot of clients that are in their citizenship phase, for example, now, and they always mention, like, I came through that wave, and you see the positive impact that these individuals have had on our community. So open arms, welcome them, and understand that they're not coming from it's not necessarily that they wanted to come to Canada. Let me put it that way. Right? It's just circumstances put them here, and the best we can do is say, okay, well, welcome, and let's figure this out now, right, together as a community.
Wow. Thank you so much, Jatin. And I just discovered that maybe we should have mentioned what you think humanitarian immigration is first, because I know some of our audience might not be aware what it really means to be under the category of humanitarian immigration.
Yeah, no, that's a good point. So humanitarian immigration can confuse people to think that there are humanitarian programs if you're outside of Canada. So there are very case-specific programs like Afghanistan, for example, where the government might open the doors to specific pathways to some kind of status in Canada, permanent residency, work, whatever, school, whatever. But when immigration lawyers, when we talk about humanitarian applications, we actually don't reference it that way. We reference it as a humanitarian and compassionate grounds for permanent residency. So it's really important to understand that difference, because humanitarian and compassionate applications for permanent residency, which are applications separate from any other pathway for permanent residency, are those applications that are made by traditionally and mostly individuals who are inside Canada already. The chances of you can technically make one if you're outside of Canada, but the chance of that being approved is something like 3 to 5%, and that's a stat. That's a statistic. The first point I always tell clients who want to explore this pathway for their family members or even for themselves is they need to be in Canada and they need to stay in Canada at least while this is processing. So humanitarian compassionate, pathway is a way towards permanent residency, but it is incredibly discretionary for the officer, and it is what we consider an exceptional remedy. You really have to be able to show why you should be granted permanent residency in Canada. And over, people who are going through this the more traditional ways, why should you be allowed to not need to go through that pathway? And that's the argument you have to make to an officer who you're hoping is going to be sympathetic to your situation.
Okay. And so who is eligible? Apart from being inside of Canada, what else do they look at?
Anyone can make it. Anyone. You can be a temporary resident. You could be facing removal. You could be a permanent resident who just lost their status. You could be somebody who is here illegally. You could be someone who has, you could be medical issues, and so medically inadmissible. I mean, really, anyone can make that application if you are a temporary resident. The most, permanent residents who lose their status, for example, typically are then facing deportation after that. And when I say lose their status, I mean it could be that they did not meet their residency obligations, so they didn't have a conviction or anything like that, but they lost because they stayed out of Canada too long. Typically, they have appeal rights. And then there are people who get convictions. There are people who are caught misrepresenting. There are people who have, those are really the two main ones, because you can't be medically inadmissible once you're a permanent resident. But the bottom line is those individuals who have lost their status they're probably the most common clients that come into our office, I'd say, is, I've lost my status, I need to appeal. And if the appeal doesn't work out, then they're going to be facing deportation, and then they're going to need to make a humanitarian compassionate application. So refugees, people come to Canada as refugees, may not realize this, but if they lose their permanent residency status, because protected status and permanent residence status are two different layers, then they still will not be removed until the government makes what's called a danger opinion. So a danger opinion is basically government, and this is usually, you can imagine, that people have criminal records, but a danger opinion is the government saying, hey, listen, we understand our obligation to the principle of non-refoulement, which is basically saying we will not send people back to countries that they were protected from or protected against. But hey, listen, this person's too dangerous. We need to send them back, and it's for the betterment of Canadian society. It's when we get clients who are in that situation where we can know that the government will have to go through this pathway, but we know they're going to lose their permanent residency anyways. They are the ones who need to apply for humanitarian compassionate application to reinstate their permanent residency.
Wow. So I have a quick question. Sorry, did I cut you off?
No, not at all.
Okay. So as you're talking about the refugees, I have this question that I keep seeing from my clients. When somebody is on refugee status, are they allowed to leave the country, and especially to travel to the very country that they could be running away from? Let's say they want to visit, maybe some short holiday or something like that. Is it something that is allowed?
My recommendation is always don't, just because you sought protection from that country. You said you can't go back there. So my recommendation is don't. Do clients go back and they're okay? Yeah, they do. But the risk is that the government can recognize that you came here as a refugee, upon landing, or at some point they can recognize that you came here as a refugee claimant, you sought protection, you got protection, your claims were based on, XYZ issues of why you can't go back.
Mm-hmm.
And you went back, and clearly you're not scared. So if the government wants to, they can do what's called a cessation application. They can initiate it and say, we're challenging this person's fear, their subjective fear of persecution and the grounds of why they claim refugee status here in the first place. So it's a risk. I always recommend my clients don't do it. They don't want to listen, and they run that risk. But my recommendation is, listen, you sought protection, staying here.
Mm-hmm.
Sorry.
Mm-hmm. Wow. Okay. So if you have an order to leave Canada, can you apply to stay in Canada on humanitarian and compassionate grounds?
Yeah, I think an agency application for people facing deportation is really common. Understand that the ground, like if you're facing deportation, of course the government has gone through certain steps to get you to that point, right? And you may have yourself put yourself in a position to have gotten you to that point. So it's not that it's difficult, for sure, and it's very case by case. You can imagine there's no black and white document requirements, for example, for humanitarian compassionate applications. There's no black and white. There's no threshold that in terms of basic eligibility requirements for humanitarian compassionate grounds, like there would be for a spousal sponsorship, for example, or a study permit or a work permit. You need to be able to do the job. You have to be married, or you have to be common law or conjugal. There are requirements there that basically government saying if you meet these requirements, you should. If you meet this criteria, you should be okay. Humanitarian compassionate ground is there is the room for creativity in this application setting is so large that you are literally playing a game of just presenting your life to an officer.
Mm-hmm.
The humanitarian and compassionate elements that they're taking into consideration, they include your establishment in the country. They include adverse country conditions, issues basically back home. You have to be able to show why you, again, should be granted this exceptional remedy for permanent resident, that is permanent, and then permanent residency, and why you can't do it from home. Why can you not go through the economic programs? Why can you not go through family class? Why can you not go through, and then even if you can't go through that, why should you be given an exception? There's best interest of the child considerations. Why is it in the best interest of this child to, and it's not even just your children, it's the law says any child. We have had cases where somebody working here is taking care of his nephew back home and his repatriation funds, those kinds of things. So it's any child in the world. why is it in the best interest of that child for this person now to be granted permanent residency in Canada? So for removal cases, I mean, the number one thing we do is we start with the family, right? We have to look at who's your family, who's here, what's going on, what's your situation, how did you get to removal? Are there mental health issues? Do we need to explore that a little bit further? Do we need to understand why sending you back home is not ideal right now? What we do is we typically ask for temporary resident permits as an alternative as well in humanitarian and compassionate applications. A TRP is for those who are inadmissible, but the government says, okay, we'll grant you status and let you stay here. People with criminal records, who are the most common category of people getting removed, well, a TRP will never, depending, most of the time at least, a TRP will not lead to any form of permanent residency. It's like immigration probation, if you want to call it. Mm-hmm. So there's a lot of, I mean, deportation cases are definitely the most complex, high stakes, and just some of the most difficult situations to overcome, especially if you've gotten, like to get to the deportation stage, especially if you're a permanent resident, you started as a permanent resident, there's a lot of history there to uncover and to deal with.
Wow. So how do they assess the evidences that the applicants present?
Well, again, it's all discretionary. It's on you to, the onus, we say, is on the applicant to provide the best possible application. So there's, again, no black and white criteria, but the case law in the federal court has definitely set up parameters in terms of how evidence should be treated and how decisions should be made in terms of the detail required. Again, it's not that the officer has to think a certain way, but the officer really has to justify, because of the nature of a humanitarian application, at least one that's done right, they have to really justify why they came to certain conclusions, and especially if they refuse. Why did they refuse? Especially if there's overwhelming evidence that points in this direction and they went this way. Why? Mm-hmm. Right? And that doesn't mean that you have to agree with their logical reasoning, their logic or their reasoning, but because again, it's so discretionary, right? Mm-hmm. But the federal court has laid out some parameters at least, and I know at least in our office, our submissions are just laid out with federal case law and guiding the officer on what they should be thinking and how they should be thinking about this, and how should they be approaching this evidence, or how should they be approaching this section of the submissions, and et cetera, et cetera. Do officers listen all the time? No, right? Of course not. But we usually then take it to appeal. We take it to the federal court and we challenge it, and then we let the judge decide if this officer was heading down the right path or not.
Wow. And how long does it take approximately for a case to be heard and PR granted?
At the appeal stage?
Yes.
So at the federal court, you apply for, we use the word appeal because it helps people understand. It's just simple. It's more simple for just the average person. But what you're actually doing is applying for a judicial review. So you're asking the court to review the decision. And at the end of the day, if you win, you don't get PR. The application goes back to a new officer to be reconsidered, as per the guidelines by the justice that makes that decision. So the appeal, that whole process can take about 8 months to a year if you are granted leave, meaning there's 2 stages to federal court. The first stage is you're presenting your case to the court. You start off, you make your arguments, then you send it to the Department of Justice, their lawyers make an argument, then you reply, and then you put it all in front of a judge. You say, here's our case, this is why we want to come here. And then the judge who's evaluating the case says, okay, yeah, this is worth the court's time, or they'll say, no, sorry, this is a waste of time for the court. And so you can imagine, that first step process takes about 3 to 6 months. And then by the time you actually get to the federal court, you probably are at that 9-month stage of the whole process. And then once the decision is rendered, it can be anywhere from like a week after the hearing, or it can be a couple months after the hearing.
Wow. Okay.
But you're looking at, I'm 12 months.
So it's not as long as I would think anyway, because 12 months appear to be like sort of a standard for most of these applications. So I think it's moving really fast then.
Yeah, I mean, it's not bad, but understand that filing at the federal court does not stop removal, for example. It does not put everything on pause. So CPS, even if you're not facing removal, CPSA can hypothetically, you could somehow be connected with CPSA. You could be jaywalking, and a police officer wants to give you a ticket, finds out you're actually in Canada without status, and CPSA gets involved. Like, I've had that happen. Something as simple as that. So it's just it's not like automatically you are protected by going to appeal, but if you are diligent and you are appealing on time, you are filing your H&C application on time, nothing is being done at the last minute, then there are ways to use the federal court to stop removal until certain decisions are made through federal court motions.
So let's talk a little bit more about appeal. How many times can you keep appealing?
Well, I mean, okay, so the way the appeals work is if your humanitarian compassionate application is refused, you go to the federal court. If the federal court does not work out, well, there's certain mechanisms, there's certain things that you have to put before the court to be able to go to the federal court of appeal. And if it's not, and if you do make that, and that you lose at the federal court of appeal, you go to the Supreme Court of Canada. We're talking years, 3 to 5 years, let's say, in terms of timelines to have everything moving this way. So the appeal, I mean, once all of that's done, if you go to the federal court, you lose and you don't pursue it any further, you can't just appeal again, you're done. You can reapply for humanitarian compassionate application if you believe there are further developments or things that need to be considered. And if you lose that again, then you can go to the federal court again. But you can't just go to the federal court over and over and over again on the same issue. So it sounds like, okay, there's options. It's very expensive and very time consuming to be able to do that over and over again, And so most people are pretty much after the federal court, if it doesn't work out, they're kind of, they're done. And they're thinking, well, maybe I'll ride this out, maybe I'll go home, maybe I'll, who knows, reapply.
Wow. Okay. So what would you advise people who come in as temporary residents and then turn that to humanitarian compassionate reasons and apply for refugee status?
Yeah. So humanitarian and compassionate applications and refugee claims for protection are two very different things. But they do in a way connect at some intersections. And what's important to understand is that if you did a refugee claim, if you came as a temporary resident, it's like a visa holder, and all of a sudden you made a claim for protection and you lose, well, the only way you can access a humanitarian compassionate application is if you have, one, a best interest of child concern, and two, if you don't, then you have to wait a year. And they will not accept your application until a year has passed. And the reality is that you're going to be removed within that year if you don't have any best interest of the child. CBSA does get involved, especially with refugee claimants, to help them get back home at the end of a refusal. But ultimately, the considerations made in the refugee claims and the H&C claims, humanitarian compassionate claims, are somewhat similar. That you're going to be kind of arguing the same type of topics, but they're assessed in very different ways. And in refugee claims, it's more personalized. In humanitarian compassionate, there's a bit more generalizations that you can get away with, as long as if you can connect the dots between how that generalized situation applies to you specifically. That's good. In refugee claims, it's more so I specifically underwent this situation, and my example of this happening in society is only to corroborate that this did happen to me. So it's a very different analysis that happens. But in terms of evidence, there's definitely some overlap. It's important to understand that if your refugee claim is denied on credibility issues, that's going to have a big issue with respect to how your adverse country conditions arguments are made at your humanitarian compassionate side of things. We have a case like that right now, and it's really tough because they just had a bad immigration consultant who handled the entire file and just didn't do a good job of it. And the board member was simply, like, what choice do they have? They're saying you didn't corroborate any of this. What you're saying, I don't believe you have a credible story, and you're done there.
Mm-hmm.
So it's that's kind of the intersection of those spaces.
Okay, so as we wrap up the team, are there any resources for immigrants who are currently applying for humanitarian compassionate visas to stay in Canada?
The government of Canada does have a guide online. It's not bad. It definitely gives you some good context and some details around how to shape the application. But look, if you're in a position that you're going to be seriously exploring a humanitarian compassionate application, get a good lawyer. The reason being, you might not even win the agency application, but if the lawyer assesses that you do have a case and they're good and they put together a good file, then you should have a chance at the federal court. Because the way federal court works is that you are bound to the application, the original application that was presented to the officer. If that application was not done well, then you're going to have a really tough time at the federal court. So when we have clients that come in that want to do humanitarian compassionate applications, we tell them right off the get-go that everything that we shared today, this is discretionary. You shouldn't be thinking this is going to be a slam dunk, even if we feel like this is a good case, because we don't control officers. We don't know how they think. We know how they think, and we don't like how they think because anyways, but the bottom line is we can't control officers. And if they refuse it, well, I'm always thinking, what if we have to go to appeal? What if we have to go to federal court? Do we have a strong enough application to at least make some kind of case there? And that's how every lawyer who works on these files should be thinking. And if you don't get that vibe when you're talking to that lawyer, find another one. Because if you're already at a position that you're contemplating humanitarian compassionate applications, you've probably gone through some things, and you probably have spent a lot of time in working with immigration trying to figure this out. And ultimately, it's going to be one of the biggest investments you make in possibly your family's future. So make sure you understand that person you're working with understands these things.
Mm-hmm. Thank you so much, Jatin. I've definitely learned a lot, and I'm sure our clients are going to learn so much as well. Thank you so much for showing law because of the many things that you've been able to do with us.
No, the pleasure is all ours. I appreciate the invite.